All right, let's talk about PTI. At a minimum, there are um, a few things that you need to look at if you're going to do PTI stuff at all. Rule 3:28 of the New Jersey Court Rules and the associated guidelines. Quite frankly, if you look at those things, you can probably be reasonably competent at handling PTI matters. Also, you need to look at the statute 2C43-12. Those things together really give a pretty good picture of what PTI is all about. What is surprising, and was surprising to me when I was a prosecutor and dealing with PTI, was how many people handled PTI cases and had never bothered to read any of those things. And they're really important. And when I say that, I'm not just talking about defense lawyers. I'm talking about prosecutors. It was one of the things that I had to direct young assistant prosecutors, that you had to actually read this stuff and not just wing it. The object of PTI is rehabilitation. And that was made clear in the very first case, State versus Leonardis. Leonardis made the point that there are no free crimes in New Jersey, that diversion is not a game. It's not just to give the defendant one free shot at committing a criminal offense. The idea here is that you divert the defendant through PTI because that defendant has some problem which is subject to short-term rehabilitation. And that's really an important concept to keep in mind, because we're going to get back to it later when we talk about some of the critical issues in PTI, in my judgment at least. Who can apply to PTI? Well, PTI is not limited to first offenders. Theoretically, at least, anybody, including mass murderers, can apply to PTI. However, the consent of the prosecutor is required for certain categories of defendants. First of all, any defendant who has a prior conviction for a first or second degree crime requires prosecutorial consent before you can even apply. A person who has completed probation or incarceration or parole within 5 years of the date of application also needs consent of the prosecutor. If a person is currently charged with a first or second degree crime or the sale or dispensing of Schedule 1 or 2 narcotic drugs and is not drug dependent, that person also requires consent to apply. A person who is involved in organized criminal activity, who is involved in a continuing criminal business or enterprise, a person who has deliberately committed a crime with violence or the threat of violence against persons. Here's an interesting one: a person who has committed a breach of the public trust, where PTI acceptance would deprecate the seriousness of the defendant's crimes. And that means, public officials, public employees who get themselves involved in criminal activity, even though they may only be charged with third and fourth degree crimes, which are normally fairly easily PTI eligible, those people must get prosecutorial consent. And that's complicated even more these days because the Attorney General has directed that the prosecutor, the local prosecutor, has to get consent from the Attorney General's office before granting PTI to such an individual. So if you're going to represent somebody who falls into that category of public trust violations, you've got a double hurdle that you have to deal with. You have to get the consent of the local prosecutor, but you always have to keep in mind that the prosecutor has to get the consent of the Attorney General in order to be able to grant PTI in such a circumstance. And finally, if you are a defendant who possessed drugs with the intent to distribute within 1,000 feet of a school, you also need the consent of the prosecutor. So how do you get the consent of the prosecutor? Well, what you have to do is to show what are called, quote, compelling reasons, end quote, to justify the admission of such a person to PTI. And we'll talk a little bit more about compelling reasons in a bit. The defendant can currently be on probation or parole and still be able to apply for PTI. There's one caveat, however, that only works if the current arrest is not going to result in a revocation of the parole or probation. So if you represent a client in that situation who's currently on probation or parole, before you apply to PTI, it's going to behoove you to check with the person's parole officer or probation officer to find out whether or not the current arrest is going to cause a revocation proceeding. Because if there's going to be a revocation of the parole or probation, then you're not going to be able to get into PTI. Otherwise, you can. The defendant's application for PTI will, in general terms, be barred by a previous PTI or a previous conditional discharge, whether that conditional discharge is from 24:21-27 or 2C36A-1. However, if you represent a client who got his diversion out of state, that may not always provide a bar. And you're going to want to look at the State versus McKeon case, which is cited in your materials. In that case, the defendant had a previous diversion for a DP, for a DUI in New York, and our court said that was okay, that diversion would not bar the defendant. However, they said the rule might be different if what he had been convicted of out of state, if what he had gotten the diversion for out of state constituted a crime. So we don't know for sure how far McKeon will go, but at least there's an argument to be made that if your defendant got his diversion out of state, that should not be a bar to his New Jersey PTI. If you want to look at this from a very practical perspective, on the one hand, you say, well, what's the purpose of doing this if my client's not going to get in? On the other hand, the question is it ineffective assistance of counsel if you don't do it? Because you don't know at the outset what the answer is going to be, even though you really do. I wouldn't want to take the chance. So if your client fits within an applicable position, I think you've got to file the application. Let somebody reject it, and then if you decide that it's not worthy of appealing, the rejection, that's another issue, that you might want to deal with. But I think you got to make the application. PTI does not apply to minor offenses. It doesn't apply to ordinances or health code violations. It does not apply to motor vehicle offenses, except to the extent that if a motor vehicle violation is a tag-along to an indictable offense, then if PTI is granted on the indictable offense, it may very well be granted as well to all of the tag-along offenses. However, when you talk, DPs, petty DPs, motor vehicle violations, however, in the instance of motor vehicle violations, it's the prosecutor who decides whether the tag-alongs will get prosecuted, will get PTI rather, or whether they're going to get returned to the municipal court and prosecuted there. I will tell you that this is one of those areas that is bargainable. So if you have that situation, and you want to have the motor vehicle violations disposed of by way of PTI rather than returned to the municipal court for prosecution, and there may be some situations where you're just as happy to have them sent back for prosecution, but if you want them handled as part of the PTI, it's one of those things that you should contact the prosecutor as early in the process as possible and talk about that, because that is one of those things that is potentially negotiable.